document or a letter barring Complete Care Medical and Clarence Jones from using my name, using my provider number, and that they weren't able to have my permission to use my name in any capacity. And so the prosecutors, investigators knew that because they asked me the questions when they came to my office. Okay, that information is also described in the article that I just described before you. Now, I do want to place this article up to look at the actual date, because the date of this letter that I had formulated barring Clarence Jones from using my name was February the 11th, 1999. Now, the charges that was levied against me by the State Attorney General and also by the federal officer, the time frame, or the timeline of that article, of those charges against us, was from October of 1999 through December of 2000. Yet when you look at the letter, and I'd like to read the letter right quick so that you'll know what it was. If it was February 11th, it's way before anything was charged that the letter was formulated, and this letter also is indicated in my police report. So it's clearly established in terms of its veracity, and so we attempted to get this letter to the law enforcement people. We called multiple times and they would not come to get the letter. And the letter reads as follows. Dear Healthcare Organization, this writing is to inform you that I no longer have any participation with Complete Care Healthcare Organization. I wish to have my name and, more importantly, my provider identification number withdrawn from this organization. Provider numbers include the Medicare provider number 082672621111 and the Blue Cross Blue Shield provider number 11082672261. I understand that an application may have been submitted for a group provider identification number with my signature. Please consider this writing as a withdrawal from that application. Clarence Jones, Kenneth Mitchell, DPM, are the owners of the Complete Care Organization. If you desire any further assistance from me in this matter, please feel free to contact me at 313-369-3604 or page me at 313-968-0477. Most sincerely, Timothy Whiteus, MD. This letter clearly established that I had barred anyone from using my name, and the prosecutors and investigators knew about it, and yet they still charged us with crimes they knew we hadn't committed. Again, once you know that a person didn't commit a crime, you can no longer be considered a true advocate of the state, and thus they were not acting as a state actor. And because all of the conduct and the things they did was illegal, it was fraudulent, then if they're not a true actor or a true advocate for the state, then they should not be allowed absolute immunity. Okay. All right, I want to bring your attention to something that's very important based on statements I said before. This is a document that was pulled up, okay, that had information regarding the requirement, absolute requirement to report any fraudulent acts of any violation of federal criminal statutes to the federal government, and it reads as follows. Failure to report a federal felony to the appropriate law enforcement authorities. If an individual knows that a fraudulent act has been committed under federal law and fails to report the fraudulent act to the appropriate U.S. law enforcement authorities, and then actively engage in concealing the fraudulent act or evidence of the fraudulent act, then the individual is guilty of a felony crime punishable up to 3 years in U.S. federal prison. Examples of acts to conceal fraud includes changing, hiding, or destroying official records in order to conceal fraudulent acts, suppression of evidence regarding the fraudulent act, directly or indirectly causing others to withhold or suppress information pertaining to the fraudulent act, making false statements to investigators regarding the fraudulent act, or any other affirmative action designed to conceal the fraudulent act from authorities. Now, this document, okay, is extremely important because when I wrote Jennifer Granholm and I gave her the information about the witness tampering of her staff, and told her that she had an obligation to report this to the federal authorities, and she didn't do it. In other words, she covered it up and became accessory after the fact, and also committed a felony called misprision of felony. You cannot know that a felony conspiracy is going on, a criminal conspiracy, and do nothing to interrupt that conspiracy. It is illegal and it's wrong. All right. Now, basically, what happened in this case was that at that point we was going through the preliminary. After the preliminary examination, we motioned Judge Giddings. Okay, the case was bound over. Okay, Judge Ball bound the case over to the circuit court, and Judge Giddings picked it up. And we then motioned to squash and desist and change the venue. Now, the defense counsel attempted to set up a smoke screen and send anyone reviewing this case down the primrose path, because what they were trying to say, that I was upset with the motions that was denied by Judge Giddings when he said that there was probable cause, and then he agreed to continue the prosecution within the court system. What I'm simply saying here is that with regards to this case, he took approximately 16 months to review the transcripts, okay? And all the evidence was in the transcripts, that everyone that testified and giving raw evidence within the preliminary exam said Dr. Whiteus, that they hadn't heard Dr. Whiteus give anybody permission to use his name. But more importantly, all the evidence of the witness tampering, okay, all of the evidence within Clarence Jones' police report was available to this judge as he read the record and as he read the transcripts. And he read Jones saying that he had not talked to me, but he sent someone to talk to me, and they never came back. And this was clear that conspiracy couldn't have occurred. He also went back and read the part of the transcript where Judge Ball asked the person that Jones said he sent to get my approval, asked him, did you hear Dr. Whiteus say it with his own mouth? Okay? And her answer, that's Sheila Stargell's answer, was no. In other words, in fact, had Sheila Stargell said, yeah, I heard him say it, then there would have been an issue of conspiracy. But if Miss Stargell, the person that Jones sent to get my approval, first of all, she never came back to tell him that it was okay. Okay? And he used my name anyway. And so I shouldn't be at fault for that. But the point is, if she came and did talk to me and never heard me say it was okay for him to use my name, then she can't testify to anything toward a conspiracy, because there's no verbal communication establishing that I agreed to allow him to use my name for any illicit purpose and being paid for it. Okay? And so as a result of that situation, Judge Giddings took 16 months. He made his decision, so we lost a pretrial motion. No big deal. Okay? I wasn't too much worried about that. Then he tried to relieve himself from the case, and he turned it over to the Honorable Paula Manderfield, and we had pretrial conferences. Okay? And so what happened when we went to the pretrial conference, Paula Manderfield did the plea arrangement, the pretrial attempted a plea arrangement the way it was supposed to. She had it in an open court. She recorded the proceedings verbatim and by the clerk, you know, and so then when we refused